Hi, everybody. Bill Prince again. Spend a few minutes with you today talking about limited liability business forms, which is the material covered in Chapter 18 of your text. You know, when I was in business school 200 or 300 years ago, it seems, we learned about three basic business forms. We learned about sole proprietorships, partnerships, and corporations. And as time has gone on, we've learned that there are advantages and disadvantages to all of those different forms. And over the course of time, people have endeavored to sort of take the best parts of each and try to incorporate them into business entities. In other words, sometimes people wanted the protection from liability that a corporation would provide, while at the same time, trying to do business in a partnership sort of an agreement or as a sole proprietorship. Many times people don't like to get involved in corporations because of the paperwork and the requirement for annual meetings and that sort of thing. And so, over the course of time, we've seen these limited liability corporations, professional corporations, limited liability partnerships spring up, which really attempt to, again, kind of hybridize the corporate form and take the best parts of each of the different business modalities and put them into one. So when we look at limited liability corporations, or LLCs, which you see oftentimes after the names of a business rather than the traditional Inc., these are hybrid forms of business which can be taxed like a partnership, yet at the same time they offer the owners limited liability of a corporation. So we avoid a lot of that double taxation, while at the same time affording owners protection for their own personal assets. As noted, an LLC is composed of one or more owners who are called members, and again, they have to file articles of incorporation or organization with the appropriate state authority, because again, as we know, states regulate corporations and the creations of corporations. And as noted here, some states require that an LLC have at least two members, while other states don't have any such requirement. And so, many times you'll see a lawyer, for example, or perhaps a doctor or another professional who doesn't want to go the PC route, organize under an LLC moniker. As noted here, an LLC can be owned in whole or part by corporations, partnerships, or foreign investors. So they don't necessarily have to be individual folks. Anytime that you do business as an LLC, you have to include the words limited liability corporation in the business name, as reflected in its articles of organization. Again, that's to identify to the public at large, not that the public at large probably gives a rip too much about the form of the businesses that they do business with, but the law says that they have to make that known in their moniker. The advantages of an LLC are that the members enjoy limited personal liability. Again, personal assets are not exposed to the debts and obligations of the business. If you have an LLC with two or more members, they can elect to be taxed as a corporation or a partnership. And again, depending on the situation, there's different tax advantages or disadvantages to that situation. They're afforded flexibility in management and operations. One of the things technically about a corporation is that activities have to be voted on. There's bureaucracies. They have to be commemorated in minutes and things of that nature. And in an LLC, you have much more flexibility in running the organization. Disadvantages to LLCs is that there's non-uniform state LLC statutes. And again, because these are relatively new forms of doing business, the case law hasn't been clear in each state as to whether or not the limit and scope of the personal liability that exists. And, and again, when you're doing business, you always want legal certainty to the best that you can accomplish. And again, in developing areas of law, you never know what judges are going to do. Compare that to corporations, which have been around forever, and the law is pretty settled about the rights and obligations of corporations and those who own them. In terms of managing these things, they're either member managed, meaning that all of the owners of the LLC participate in its management, or they're manager managed, where the individuals who own the LLC designate non-members to run the LLC for them. In the absence of an agreement to the contrary, all members of an LLC are entitled to participate in its management. As we saw when we talked about partnerships, again, to avoid litigation and uncertainty in the future, there should be an operating agreement, and that operating agreement should be in writing amongst the members of the LLC, and it should address issues involving management, profit sharing, transfer of ownership, dissolution, and other important issues. Again, failure to have those kinds of things result in many of the kinds of cases that we see in our textbook. The operating agreement can also include provisions governing decision-making procedures, voting rights, members, meetings, and the like. And if there is not if there's a dispute and it's not covered in the operating agreement, or there is no operating agreement, courts generally will apply partnership principles where there are there are more than one member of that organization. Again, the disassociation or ending of an LLC can occur at a set time if it's provided for in the operating agreement. Otherwise, the LLC can dissociate when a member chooses to leave. And again, we saw that across the country with regard to corporations, we've started to see these uniform corporate laws. We're starting to see that with Uniform Limited Liability Company Act as well. Not all states have adopted this, but again, states are trying to become more uniform in the way that it treats limited liability corporations. And so somebody can be thrown out, I guess disassociation is a better word than thrown out, but they can be thrown out if the other members vote them out, if the other members go to court and get an order ordering somebody out, if somebody dies, becomes incapacitated, files individual bankruptcy, or assigns their interest in the organization to the benefit of the creditors. All those can result in a member being disassociated from the organization. A member who is no longer associated with the LLC forfeits his or her authority to act for the LLC and participate in its management. They cease to owe the LLC a duty of loyalty and continue to owe it a duty of care only with respect to the events that occurred before the disassociation, and they are generally entitled to have the remaining members purchase their interest in the LLC, sort of like a partnership. In terms of the partnership or the LLC ending, terminating, it can be dissolved by the occurrence of an event stipulated in the agreement. In other words, maybe somebody dies or something like that. It can end per vote of the remaining members. Or again, if the thing ends up in court where the members are fighting with each other, a judge can order that the LLC be dissolved. All right. We also have limited liability partnerships and limited partnerships. And again, if you remember, one of the big disadvantages of partnerships was this idea that one partner can bind the other partners civilly and tortiously and that sort of thing. And so, you really have to be careful about who you associate with. And so when you have limited liability partnerships, members are afforded the tax benefits of the partnership, but they can be able to avoid personal liability for the malpractice of other partners. So, if I'm associated with a group of doctors and one of the doctors cuts off the right leg instead of the left leg, we can have our organization formed in such a way that that I will not have individual liability for that other individual's malpractice. The LLP might well have that, but my personal assets would be protected. So, as noted here, LLPs are traditionally designed for professionals who have historically done business as partners, so like attorneys, accountants, doctors, and that sort of thing. But they want to limit their liability for their partners' misdeeds. And generally, again, it needs to be structured properly. There needs to be a proper partnership agreement and that type of thing. There's also what are known as limited partnerships. And in limited partnerships, you have a partnership where you have general partners who manage the business on a day-to-day basis. And those folks are potentially personally liable for the wrongs of the organization. However, you can also have limited partners who contribute capital to the organization, but they don't participate in management. And so those limited partners, their liability gets limited to the amount of resources that they've put into the partnership and no more. Okay, real brief discussion of limited liability corporate forms. Our next discussion, we're going to talk about the granddaddy of them all, corporations. So we'll see you then.